Great, well today we're going to look at the interesting case of Penny in the Commission of Inland Revenue 2012 1 NZLR at page 433. This case is a fascinating extension on the list of anti-avoidance cases following the Ben Nevis decision. So today we'll cover the key facts, legal issues, the decision made, provide some comments on the case and look at what's happened since this case. Here's a picture of Mr. Hooper, one of the doctors. This case concerned an anti-avoidance challenge by the Commissioner under what was then Section BG1 of the Income Tax Act 1994, ostensibly the same as what is now under BG1 of the Income Tax Act 2007. Of course, those sections are followed and supported by GB1, which allows the Commissioner to adjust things in the case of an anti-avoidance decision. The case involved two orthopaedic surgeons, one Ian Penny and Gary Hooper. Both surgeons had restructured their existing practices to utilise a combination of limited liability companies and trusts. Particularly, each surgeon had settled a trust, owned a company, and that company purchased their current existing practice. The case made headlines at the time. In fact, it even has its own Wikipedia page. Mr. Hooper restructured his practice in 2000, the same year the top personal tax rate was increased. He incorporated a company in which Mr. Hooper, his wife and family trusts were shareholders, ostensibly to allow shareholder salaries on his part and his wife's part. Penny's restructure was similar in terms of using the same model of a company owned by a trust, but notably it took place in 1997, several years before the tax rate increase. Each trust, having purchased established a company which had purchased the practice, profit then was drawn down from the company into the trust, and each trust then paid their respective men a small salary, avoiding much of the top tax rate of 39%, whilst the rest of the practice's income was taxed at the 33% corporate tax. I say small tongue-in-cheek in that by most standards $120,000 per annum is not considered an insignificant wage. Hooper's income shrunk from circa $650,000 down to $120,000, and Penny's income dropped initially from circa $750 to $302, then to $125, then down to $100, which was in both cases an average of $500,000 below what the Commissioner considered commercial. If you have a look at the textbook we've got on page 1013, Nigel Smith has inserted quite a useful diagram with a table that shows the movement of revenue and how everything worked. You'll see there that the average tax saving for Mr. Hooper was circa $24,600, and for Mr. Penny about $33,600. So both these gentlemen had initially thought they were onto quite a good thing. What's interesting is that when questioned by the court, both indicated their salaries were at levels substantially below what they would have accepted in an arm's length context. For instance, Mr. Hooper admitted that had he been employed by an independent company, he would not have under any circumstances accepted the salary he effectively paid himself. I must point out I'm pleased that I wasn't representing him at that point. Mr. Penny's trust similarly made interest-free loans to him, putting any protected revenue back into his personal name. There was no reference in the case to that loan being documented with any security provisions in favour of the trust. This is an important fact, as both gentlemen made much to do of the alleged purpose of having set up the structure to protect their revenue from third-party liabilities. In a situation where a client puts a business into a company trust structure, then effectively extracts all of the income back out into their own name, it doesn't inspire the court with the authenticity or otherwise of that claim. In Mr. Hooper's case, revenue was also allocated to his daughters as beneficiary income. There was nothing abnormally significant in that. Moving down, there was no material change recorded in terms of the surgeon's professional or business position beyond the change of personal income claimed from either of them. In short, on Friday they were both earning over $500,000. On Monday, with no other material change at all, they were suddenly on circa $100,000 to $120,000. The Commissioner understandably alleged the arrangements entered into constituted tax avoidance. Each of the gentlemen paying themselves at least $168,000 less than the Commissioner contended they should have been paid. The Commissioner recalculated each surgeon's incomes by deducting the actual company expenses from actual receipts to attribute to each of them a commercially realistic salary. The surgeons appealed. Key legal issues. Section BG1 of the Income Tax Act. A tax avoidance arrangement is void against the Commissioner for income tax purposes. Conversely, GB1 allows the Commissioner to adjust amounts of gross income, allowable deductions and available losses included in calculating taxable income. So the key legal issue was this annual setting of a salary a tax avoidance arrangement. The court had the benefit of Ben Nevis looking at an overall transaction. A key question here was just this one component, this one element of this whole structure sufficient to create a tax avoidance arrangement? Emphasis on the word arrangement. At the time, there was much reference in the popular press with respect to the choice of structures. This, I suspect, was following on the Ben Nevis decision. However, if we look in fact at this particular case, the core legal issues were to do with the artificial or the alleged artificial setting of salaries so as to reduce the impact of the increased top tax rate, the rate having increased from 33% to 39%. The legal issues are set out in two sequential questions considered by the court. Question 1. Was the use of the structure, as opposed to the structure itself, beyond parliamentary contemplation so as to result in a tax avoidance arrangement? Particularly, question 2, was the fixing of comparatively artificially low salaries explicable other than for the purposes of tax avoidance? In short, was there a genuine commercial reason? The Commissioner argued the concept of a commercially realistic salary. So consequently an issue was, does such a concept exist? Core to this discussion was that other than a change in the tax rate at the time, there had been no material or commercial change in the taxpayer's practice or business. So what was the court's decision? Initially this was decided in the High Court, and the High Court decided in favour of the taxpayers. The Commissioner, unhappy with this ruling, appealed to the Court of Appeal. The material decision on appeal in the Court of Appeal was rendered by a majority decision of the Court of Appeal, who decided in favour of the Commissioner. The taxpayers then appealed to the Supreme Court, which upheld the majority decision by the Court of Appeal and dismissed the case of the appeal in favour of the Commissioner. The material decision was that because the artificial annual setting of salaries had no material purpose or effect other than to avoid paying a higher rate of tax, the taxpayers had engaged in a scheme or arrangement for tax avoidance. The Court looked for and explored In fact, they went to great lengths to try and find an authentic commercial reason, but found no material commercial considerations, leaving the only possible conclusion available to the court that the taxpayers had artificially contrived to alter their income purely to avoid a higher rate of tax. The court upheld the choice of structures as legitimate. It was submitted at page 459 that there is no concept of a commercially realistic salary in the Income Tax Act. Also, that commonly family transactions are not based on market valuations. The court accepted that and clarified the position that if the salary is not commercially realistic or objectively is not motivated, this is the choice of level of it, is not motivated by a legitimate, that is non-tax driven reason, it will be open to the Commissioner to assert that it was or was part of a tax avoidance arrangement, and that, in summary, is precisely the decision of the Supreme Court. Commentary. Having read through this case in some detail now and looked at some of the commentaries at the time, I quite agree with the Commissioner's view. In the absence of any commercial options to the contrary, the only genuine consideration was tax reduction. The only issue here is the difference between the concept of mitigation in terms of picking the best possible thing and evasion. Some of the difficulty here, of course, was that we were talking about an existing practice and that there was no material change other than tax, particularly as anything that might have been used to protect the gentleman's wealth was undone by them pulling it out and expending the money in their own personal names. The decision of the Supreme Court was presented by Blanchard J. Paragraph 34 of his decision at page 453 is the basis of the ratio in this case, and I found particularly helpful in analysing the basis on which the judgment was determined. To me, the crux of it is this paragraph. Quoting Ben Nevis at 105, as Justice Blanchard said, tax avoidance can be found in an individual step in a wider arrangement. That step, when taken, can make the wider arrangement a tax avoidance arrangement. Where a particular step is done repetitively, such as in this case in the annual setting of the salary levels, the step may or may not amount to a tax avoidance depending on its purpose or effect in each occasion. If, for example, in one year the salary was set so as to absorb all the company's profits, it could hardly be said that any avoidance was involved. To me, this is a fascinating pragmatic take, in my view, support of legitimate structuring as opposed to Ponzi structuring. His Justice then went on to clarify, on the other hand, if the setting of the annual salary is influenced in more than an incidental way by a consideration of the impact of taxation, the use of the structure in that way will be tax avoidance. The question to be asked is therefore why the salary was fixed as it was on a particular occasion. Whether that involved tax avoidance can be answered by looking at the effect produced by the fixing of the level of the salary in combination with the operation of the other features of the structure. And what he was particularly clarifying there was, were there in fact genuine commercial reasons? The case further builds on Ben Nevis, pointing out that the trading structure with a trust company does not per se involve tax avoidance. The arbitrary setting of salaries on an annual basis for a proper commercial basis is valid. Where a dominant purpose is protection, one thing I take from this case is it's important to ensure the integrity of the structure is duly maintained. It is completely unhelpful when you've gone to the process of moving everyone's financial assets into a trust to then pull them out into someone's name again. The precepts and model set out in this case was not revolutionary, mirroring a prior Privy Council case from 1967. In other words, the advisors should have known better. What has happened since this case? The case, whilst it initially caused much of a stir, does seem to have settled in as a key consideration when advising private clients. It was so significant that the IRD issued an amnesty, particularly to medical professionals who had been engaging in a similar practice. The amnesty was so significant that it was extended through to the 2013 tax year. Case has been upheld and referred to in a number of decisions, both as to its commentary on the tax position and as to some matters of procedure. In short, on appeal, please don't repeat all the facts, said the court. The most relevant and fascinating decision that refers to the Penny case is a decision of Justice Heath and White in the Commission of Inland Revenue. And of particular interest is that this judgment was held between when the Court of Appeal decision was made in the Penny case and the Supreme Court, and consequently, most unusually, it's actually cross-referenced in the final judgment of Penny the Hooper case at the Supreme Court level. The decision in White provided further judicial insight into the concept addressed in Penny and Hooper, and supported what was ultimately the Supreme Court's core ratio and commentary on valid commercial or non-tax driven considerations when setting salaries. In the White case, briefly, Dr. merged to private practice with her husband's 2 avocado orchards. Consequently, there were 2 years when that particular company made losses in the orchards. Those losses were funded by the medical practice income. Dr. White drew little or no income in those 2 years, and the Commissioner contended that she was running the same form of tax evasion scheme as Mrs. Penny and Hooper. The court noted that a company not having sufficient cash to pay a salary was in fact quite a legitimate commercial reason for withholding allocation of revenue, and dismissed it. There was nothing contradictory in the White case. In fact, it validates the Penny and Hooper case and draws on the exact paragraph 34 I mentioned earlier. The case has caused much of a stir and has been upheld and referred to in a number of decisions. Really appreciate you listening and trust you find it as interesting as I do. Cheers.